Rob Warden, you just co-authored a book called Greylord. What's it about?
It's about judicial corruption in the city of Chicago and a federal investigation, a sting operation that exposed the situation.
How did the roots of this corruption in the city, what was the climate that allowed corruption to begin in the court system here?
Chicago has always been a one-party town, or at least since the 20s. And the Democratic organization has controlled absolutely every facet of the life and all three branches of the government, the executive, the legislative, and the judicial. To become a judge in Cook County, you had to be slated by the regular Democratic organization. You got slated by doing political work. And therein were the seeds for corruption. I think that it wasn't a very big step from taking a call from an alderman or a committeeman to actually taking money to fix cases. And of course, this investigation didn't get at that underlying corruption, the political fix that's possible in the courts of Cook County, but only at the financial corruption.
What's the time frame your book was written in? What's the time period that this story covered?
The investigation, the federal investigation of the Cook County Circuit Court system began in 1979, and this investigation, I believe, is still continuing today.
What was it that attracted, if it had been going on for such a long time as you describe, and it was really sort of fundamental to the political structure in the city, what was it that finally got people interested in investigating, finding out what was going on, perhaps putting an end to it?
Well, as you say, for years and years it had been going on and people had been aware of it. In the 70s, when Jim Thompson, presently the governor of Illinois, was the U.S. attorney here, he had begun an investigation of the legislative branch and convicted a number of Chicago aldermen with expansive use of the federal mail fraud statute. I think that they just finally got around to looking at the judiciary. Now, there had been a very highly publicized case in Cook County in the late 70s and involved a mafia hitman who, there were two eyewitnesses, and that's very rare in a case like this, who had actually seen a murder take place. This hitman was acquitted, and the state's attorney at the time, Bernard Carey, was extremely upset. He'd gone to the U.S. Attorney's office. Then at about the same time, a couple of prosecutors from the county system had moved over, or one prosecutor had moved over from the state's attorney's office into the U.S. Attorney's office and was very concerned about judicial corruption, and there were the seeds for the Greylord investigation. Now, this investigation involved FBI agents masquerading as defendants, as defense attorneys, prosecutors, and in one case, a judge. It was a massive, massive sting operation. And that operation really didn't take them very far. It only got 3 or 4 judges, but at about the same time, a Chicago lawyer, reporter, my co-author Jim Toohey, had done a major story on a phenomenon known as hustling. In Illinois, if you're arrested and charged with a crime, a minor crime, a bond is set. You can post 10% of that bond with the court and you're free. Now, in many states, there are bail bond systems where you give a bondsman 10%. If the bond is $2,500, you pay $250 to the bondsman. Well, in the early 60s, Illinois had such a system, and it was corrupt, and consequently the legislature abolished it and put the various counties into the bail bond system. So when you post bond, you get a bond slip. A few years after establishing this system, the legislature, in all of its wisdom, made those bond slips negotiable instruments, or at least to the extent that a defendant could endorse it, payable directly to an attorney. So that was the birth of the hustler. People would walk into court, maybe they'd been charged with shoplifting or maybe a traffic offense or whatever, and they'd have a bond slip in their hand. And what Jim Toohey observed in 1980 when he went out and looked at these branch courts were the judges and court personnel steering these defendants to particular lawyers. Now, at the time, of course, we couldn't prove why they were steering them, but we knew that it wasn't because the judges had great confidence in the legal ability of these lawyers. After we ran this story, the federal government picked that up. They checked the bond slip refunds because there were records in the, and they were able to show that these attorneys weren't paying federal income taxes on all of the money that they were receiving, and they were ultimately able to persuade those attorneys to testify against judges they were paying off. And that became the major, the centerpiece of Operation Greylord.
Where did the name come from?
There are different stories about where the name came from. We were told initially, in fact, the U.S. Attorney, the recent U.S. Attorney Dan Webb, told me that Greylord was a sarcastic reference to the English Lord Chancellors, and that's the English spelling of Grey, as you will see. Someone said more recently that actually there was a racehorse named Greylord, and that they just pulled the name out of the air. I don't really know. There are different perceptions.
You made some reference in the early chapters about the FBI being predisposed towards sting operations at the time. Can we talk about that?
Yes. Sting operations are obviously, they draw a great amount of publicity. They get heavy coverage on television and the newspapers, and I think the FBI grew enamored of those in the 70s. J. Edgar Hoover at one point supposedly had prohibited them or had very greatly limited them, believing that they were not really an effective use of law enforcement. But this took off right after Abscam, which of course was, you know, the FBI just got all of this wonderful publicity, and it seems that almost every sting operation they conducted had to be just a little bit bigger and a little bit better than the one previously, and this was going to be the granddaddy of them all, Operation Greylord. Unfortunately, the sting portions of it didn't really work all that well. I think only 3 judges were actually convicted as a result of the sting. And the FBI agents, this involved setting up phony cases to run them through the system. Mm-hmm. So, for instance, the FBI would stage a strong-armed robbery in which the victim would be an FBI agent and the robber would be an FBI agent. They staged one right down on Michigan Avenue on the Magnificent Mile, right in front of Marshall Field and Company one day. And they waited until there was a police officer nearby, and the robber starts running, and the victim chases him and ultimately tackles him, and the police arrested him. Well, suddenly people were arriving on the scene, and they were volunteering to testify, saying, "I saw the whole thing." Well, the police knew that this isn't the way a real one goes down. Furthermore, when they got the guy over to the police station to book him, they searched him and pulled out his wallet, and lo and behold, he was carrying his FBI identification card. In another case, the FBI had telephoned an anonymous tip to the police on the Northwest Side that a man was sitting in a restaurant with a satchel full of cocaine. The police walked in. Here was the man, just as the anonymous caller had described. They walked up to him and said, "What's in the bag?" "Cocaine." Just like that. Well, police got wise that things don't really happen quite like that. And so the police then had to be taken in on the investigation. They had to be assured that they weren't the targets of whatever the FBI was doing, and they were. And so they established a few more that they really did get cases into the system, except it's extremely costly, very hard to do. In the first place, we had more than 300 judges in the Cook County Circuit Court at that time, and they sat in various divisions, but the assignments, the case assignments were random. So if you suspected that a judge was crooked, even if you staged a case, you had no way of assuring that it would get assigned to the judge where you wanted to attempt to make the payoff. There are other problems. I mean, for instance, they had an FBI agent ram a car into a light post, and he poured liquor all over himself and had just enough so there would be some on his breath. The police came. It was close to the end of a shift, and they didn't want to go through the paperwork, so they just threw the guy's keys down the gutter and poured the booze out and sent him home. So they'd go through all of these elaborate things, and then sometimes it would all come to naught because it simply wouldn't work.
Is that sort of a side story to your book, or do you hope also to show that these kind of operations by the FBI aren't the best way to go about it?
My personal view is that it really isn't an efficient way to investigate corruption.
But that's not the main point you're trying to make.
Oh, no. I mean, there was certainly, was, and I believe continues today to be very serious corruption in the Circuit Court of Cook County.
Mm-hmm.
And this investigation has certainly gone a long way toward making the people who are engaged in that very uncomfortable, if not rooting it out entirely.
Your book seems to have a number of villains. I read one review and it said it reads like a novel. One of the things that strikes you is really how blatant some of the actions were, how some of the quotes are almost outrageous, almost as if they were written by a Hollywood scriptwriter as opposed to...
Well, yes. Now, you understand that, of course, these things came out in the trials, and these weren't things that you or I could go into a courtroom and observe if you were looking like, I mean, Wayne Olson, one of the judges who was convicted, saying, "I like people that take dough because you know where they stand." Or Judge Raymond Sodini, when he saw court personnel in the back of his courtroom who appeared to be bickering over splitting up payoffs that they'd received from an attorney. He told his bailiff, "Go tell those guys if they're talking about money to go in the back room and do it, not to talk about it, you know, out here in the open." Well, all of those kinds of things came out, actual testimony in trials, but they weren't something that we could have observed as journalists or any other person who just comes into the court could see. Now, you could see a lot of things that were going on, but Jim Toohey and I had been covering the courts in Cook County off and on for more than 20 years, and if you had asked me to come testify before a grand jury, I wouldn't have a single incident that I could ever have related, which is why it takes a massive federal investigation of this sort to root it out.
Mm-hmm. Who are the victims in stories like this?
Well, of course, we, the citizens, are the ultimate victims. If the justice system is corrupted, we're victims in a number of ways. Obviously, if the drunk driver isn't fined or something, we're financially hurt, but that's a minor part of it. I think that it breeds disrespect for the law. It creates more lawlessness than we would otherwise have. And the Cook County Circuit Court had the reputation of being corrupt and has the reputation today of being corrupt. And I think that's the real damage that's done by these appearances that justice is not done or that a case can be fixed. Some judges can be wired. And another aspect of this corruption, just because of the reputation of the system, the average person who was charged with a misdemeanor believed that the system was corrupt. So if a lawyer said to him, "Well, my fee will be $500," and then comes back right before the trial, or usually a bench trial, and says, "Well, we're going to have to pay off the judge, it'll be another $250," it was a way that it just enabled lawyers to extort money in that way. That was called rainmaking by the people who engaged in it. That is, telling the client that the lawyer was going to pay a bribe, but actually, of course, just pocketing the money. And that was possible simply because of the reputation of the system. Interestingly, lawyers could tell, I mean, of course, because of the practice that this is the evidence, maybe a witness is not going to show up, or the evidence is very weak, the defendant's going to be acquitted for sure. The lawyer would know, and so you could do this with a great deal of certainty. But in a case where the lawyer was surprised, if the judge heard the evidence and said, "No, I find the defendant guilty," the lawyer would then go back and say, "Gee, who have you upset in the prosecutor's office? There was tremendous heat in this case, and the judge just couldn't do it. Here's your money back."
In most cases, were we talking about large sums of money?
Well, in some cases we were talking about $500, $1,000, but in most cases, in some cases, we were talking about extremely small amounts of money. I think one of the things that amazed observers in Chicago was not that the corruption was so rife, but that justice was being sold for so little. In some cases as little as $10 a case.
Early on in your book, you tell the story, struck me, of one particular judge who occasionally didn't want to come to court.
Oh, yes.
Will you tell that one?
Well, that's Judge Sedini, who ran he presided over a gambling court at Central Police Headquarters, and early in the morning he had to handle what's called the bum call. This is the call of all of the people who were swept off the streets, basically for safekeeping on any given night in Chicago. They're all brought in. Well, Judge Sedini, who drank a lot, would sometimes have a hangover in the morning, and he'd call in and tell his bailiff to tell the police sergeant assigned to his courtroom to put on the robes and do the bum call. So the police sergeant would literally put on the judge's robes, sit there and go through this call, and these defendants were all just dismissed. They were charged with an offense known as disorderly conduct, which is really not much of an offense. They're more disheveled and pathetic than disorderly, and they're all released. But one of the stories that we told here, one day a drunk was being particularly boisterous in the back, and they saved his case until last and brought him in and sentenced him to death. It was a rather unsettling way for him to begin the day, I would suspect.
Talked about the victims and certainly the many villains, as it were, in the story. Are there any heroes? Are there any good guys in this book?
Well, I would say the best guy was a Chicago lawyer named Keith Davis, who, when we did our initial expose on hustling in 1981, was the person who went around to the courtrooms with us, showed us what was going on, sort of exposed a lot of the conduct that ultimately became the central piece of Greylord. The prosecutors, by and large, of course, we portray as very politically ambitious people. I think a lot of them were well-motivated, did a very good job, and were certainly not anti-heroes, but I mean, they were just doing their job. To me, Keith Davis would be the hero of Greylord.
And you and Mr. Toohey were working where at the time?
A Chicago Lawyer.
Which is
it's
what?
It's a monthly publication that it's now 11 years old, and we've done investigations into corruption in the judiciary and the legal profession for these 10 years. And that's where why we got onto this story so early on, and were able to find out so much about it.
Mm-hmm. How long was it before the city's major daily newspapers were writing about it regularly?
They didn't write about it regularly until the U.S. government began to leak it. Leaks from the prosecutor's office that this investigation was going on. And then, of course, it was banner headlines. Mm-hmm. But that wasn't until 83 or 84.
Why, can you, knowing how the system works, how government sometimes tries to influence the media and the like, why was the Justice Department leaking the story at that point? What did they see as an end to be served by it?
They wanted to, this is my view, I mean, they would dispute this, but I think that they wanted to create a general feeling of paranoia among the people who were under investigation and get them to come forward and cooperate. Furthermore, the story had actually begun to leak to some of the targets. They had served a subpoena on one of the lawyers who had been involved in payoffs to judges. He had been to a defense lawyer, and so they knew it was just a matter of time until it was going to leak. And they controlled it very well. They leaked it to very specific people, and resulted in massive international publicity months and months and months before the first indictments came down.
Mm-hmm. In the early days, before the popular press got involved in it, was this ever a dangerous story for you to write?
Oh, I don't think so. No, I don't think that, you know, most of the judges involved here in this corruption, not all of them, but most of them, were really rather pathetic. They had bad alcohol habits. They were alcoholics. And what many of them were doing was just taking enough money to support a good drinking habit, you know, $50, $100 a day to pay the bar bill at night. And no, I don't think there was any danger that anybody was going to be killed or anything like that. And there were certainly no threats that came to our attention.
In the end, out of both the sting operation and the larger investigation, how many indictments, how many convictions?
There were 86 or 87 indictments, and they have all been convicted with 2 exceptions, and among those are 14 judges, and the rest are court personnel and lawyers.
When you look at the sentences, what was the attitude by the judicial system in policing its own? You got light sentences, heavy sentences for this?
Oh, I think they were extremely heavy. I think that the sentences were very heavy. In fact, I think the federal judiciary, when it came to dealing with this problem, was appalled. And many federal judges, of course, came out of the state system, and they were genuinely appalled by what they found.
Yet you indicate that it continues, the corruption continues.
There has, unfortunately, there's been no systemic change in the system. It continues to operate pretty much like it did in the past. Now, this practice of hustling, I mean, that's largely gone. It was too apparent and too open. But whatever the underlying problems were, which I believe stem from the political selection of judges, the lack of independence of the third branch of government from the other 2 branches, the possibility of the political fix, that remains. It's as prevalent today as it ever was. We've driven some of the worst crooks, I think, off the bench, and people are a lot more subtle. But this is not the end of judicial corruption in Cook County.
What's it going to take for a systemic change?
Well, first, I think we'd have to change the system in which the chief judge is chosen. He's presently elected by the other judges of the court, the ones he's supposed to be supervising. Now, that's not really much of a very good management structure, as I'm sure absolutely every management consultant in the world would agree. The other is that we need to change the way in which judges are chosen. We need it's called a merit selection system. We need to replace this political selection process with a merit selection system. Now, those are the 2 biggest steps that could be taken, and of course neither of those has been taken.
Where do you see impetus for a change like that coming from?
If this investigation and the massive publicity couldn't do it, I don't know what really could. In recent years, however, it's been rather interesting to observe that the Democratic organization has lost control. It's no longer the monolithic force in Chicago that it once was. In 1984, the Democratic slated candidates for judge were defeated by people who happened to have Irish names. This is a big Irish city, and so if your name's Kelly or O'Malley, you have a very good shot, a much better shot than someone with a non-Irish name. And it just turned out that in 1984, the organization or the machine slated people with non-Irish names. They had opponents who had Irish names or more Irish-sounding names, and they won. It sort of, left me with the view that the only person who could favor the present system is an anarchist, because the organization can't control it anymore. So ultimately, when the organization loses control and the politicians understand that they've lost control, perhaps we can have a meaningful reform. But this investigation didn't bring that about.
Why did you and James Toohey decide to turn this into a book?
Well, we just thought it was one heck of a story. It's got the elements of guys and dolls. It's got tragic elements, comic elements. And it's an important story that had never been told. And there was no other way. One of the reviews said that, gee, there's very little new here. There's no new research. Most of this had been published before in various publications, including our own. And that's true. but there was no place for that it was all pulled together, and that's what we thought we could do in this book.
Is this a peculiarly Chicago story, or are there lessons for the country to learn from this?
I would hope that it's not as bad anywhere else in the country as it was or is in Chicago, but just like police corruption is not a purely Chicago phenomena, it exists everywhere, I assume that this exists to some extent in every large metropolitan area.
Talked a little bit about the federal judiciary being outraged by this. Do you know for sure or have any sense that it is encouraging some review of the process in other cities around the country?
I really have no idea, except of course the reform, the organized bar has become increasingly concerned with ethics, appearances, and I think it's probably having an effect everywhere. But I don't really have any first-hand knowledge of what's going on anywhere except in Chicago.
If you and James Tuohy could write an epilogue to Greylord a few years from now, what would you hope that would be?
I would hope that we could find more heroes. I would hope that we could find someone who would be the hero of the sequel. I'd like to find at least one good, honest person in the system to make a hero. And unfortunately, we didn't have that this time. That will have to wait for the sequel.
And in addition to that, ultimately that the system will be reformed as well? Or have you given up hope on that?
Well, I would hope that the system would be reformed, and that's why we would have a hero who finally brought this about.
What did you learn by writing the book? Anything?
Yes, you always learn things when, even if you, before you actually start writing something, it helps clarify the thought process. That's why I see sometimes courts issue decisions and say that a written opinion will follow. I think that that's wrong, because I think the writing process is what clarifies that opinion and the thought process. And you, in the writing process, you run against problems that hadn't occurred to you or that you hadn't focused on quite as well, and you learn a great deal. And I think that at one point it just really dawned on me how thoroughly corrupt this entire system was. I mean, we had judges who were popping off the bench to take payoffs in the middle of trials. We had, in one case, a lawyer who was literally involved in, if you invited him to dinner at your house, he'd case the joint for his burglar friends. He once set up a money laundering scheme for some friends of his, and he changed some gold Cougarans for cash for them in his office and arranged to have them hit in the, and mugged in the lobby of his building. We had prosecutors who were authorizing the bugging of clients by lawyers. I mean, to me, this is just thoroughly, a thoroughly distasteful thing that was exposed here. And it really, having covered it for all these years, writing this book brought that all into focus for me.
Rob Warden.
System. So when you post bond, you get a bond slip. A few years after establishing this system, the legislature, in all of its wisdom, made those bond slips negotiable instruments, or at least to the extent that a defendant could endorse it, payable directly to an attorney. So that was the birth of the hustler. People would walk into court, maybe they'd been charged with shoplifting or maybe a traffic offense or whatever, and they'd have a bond slip in their hand. And what Jim Tuohy observed in 1980 when he went out and looked at these branch courts were the judges and court personnel steering these defendants to particular lawyers. Now, at the time, of course, we couldn't prove why they were steering them, but we knew that it wasn't because the judges had great confidence in the legal ability of these lawyers. After we ran this story, the federal government picked that up. They checked the bond slip refunds because there were records in the, and they were able to show that these attorneys weren't.
Rob Warden, you just co-authored a book called Greylord. What's it about?
It's about judicial corruption in the city of Chicago and a federal investigation, a sting operation that exposed the situation.
How did the roots of this corruption in the city, what was the climate that allowed corruption to begin in the court system here?
Chicago has always been a one-party town, or at least since the 20s. And the Democratic organization has controlled absolutely every facet of the life and all three branches of the government, the executive, the legislative, and the judicial. To become a judge in Cook County, you had to be slated by the regular Democratic organization. You got slated by doing political work. And therein were the seeds for corruption. I think that it wasn't a very big step from taking a call from an alderman or a delegation of the legislative branch. And convicted a number of Chicago aldermen with expansive use of the federal mail fraud statute. I think that they just finally got around to looking at the judiciary. Now, there had been a very highly publicized case in Cook County in the late 70s and involved a mafia hitman who there were two eyewitnesses, and that's very rare in a case like this, who had actually seen a murder take place. This hitman was acquitted, and the state's attorney at the time, Bernard Carey, was extremely upset. He'd gone to the U.S. Attorney's office. Then at about the same time, a couple of prosecutors from the county system had moved over, or one prosecutor had moved over from the state's attorney's office into the U.S. Attorney's office and was very concerned about judicial corruption, and there were the seeds for the Greylord investigation. Now, this investigation involved committing to actually taking money to fix cases. And of course, this investigation didn't get at that underlying corruption, the political fix that's possible in the courts of Cook County, but only at the financial corruption.
What's the time frame your book was written in? What's the time period that the story covered?
The investigation, the federal investigation of the Cook County Circuit Court system began in 1979, and this investigation, I believe, is still continuing today.
What was it that attracted, if it had been going on for such a long time as you described, and it was really sort of fundamental to the political structure in the city, what was it that finally got people interested in investigating, finding out what was going on, perhaps putting an end to it?
Well, as you say, for years and years it had been going on and people had been aware of it. In the 70s, when Jim Thompson, presently the governor of Illinois, was the U.S. attorney here, he had begun an investigation of FBI agents masquerading as defendants, as defense attorneys, prosecutors, and in one case, a judge. It was a massive, massive sting operation. And that operation really didn't take them very far. It only got 3 or 4 judges, but at about the same time, a Chicago lawyer, reporter, my co-author Jim Toohey, had done a major story on a phenomenon known as hustling. In Illinois, if you're arrested and charged with a crime, a minor crime, a bond is set. You can post 10% of that bond with the court and you're free. Now, in many states, there are bail bond systems where you give a bondsman 10%. If the bond is $2,500, you pay $250 to the bondsman. Well, in the early 60s, Illinois had such a system, and it was corrupt, and consequently the legislature abolished it and put the various counties into the bail bond